SJC-13440, Fallon Community Health Plan, Inc. v. Katie Dishnica and another.
Good morning, Your Honors, and may it please the Court. Francesco DeLuca on behalf of Fallon Community Health Plan, Inc., the appellant in this matter. This court should reverse the district court's judgment awarding Ms. Jefferson unemployment benefits because the evidence conclusively demonstrates that she knowingly violated a reasonable and uniformly enforced policy that Fallon had maintained, namely a mandatory vaccination policy requiring its home health care workers to receive a vaccine against the COVID-19 virus.
But she wasn't able to comply due to her firmly held religious beliefs, right?
That's correct, Your Honor. That was her justification for not receiving the vaccine.
And that it wasn't somehow she was making it up or anything like that?
No, Your Honor. Fallon had no reason to doubt it. Fallon did not address the sincerity or integrity of any of its employees' religious beliefs. What it did was it went through a process of evaluating whether it could accommodate those beliefs while accounting for patient safety.
And they realized they couldn't do that?
They realized they could not do that.
And she was dismissed?
Yes, correct.
Didn't she get unemployment benefits?
This is related to the Chief's question. Hold on for 1 second. This is related to the Chief's question.
Your Honor.
Because I was a little bit surprised that your reply brief, when we sent out the amicus solicitation, both bases referenced the sincerely held religious beliefs. How is that not directly implicating the Establishment Clause? And when we now talk about the other statutory basis and whether or not there's substantial evidence for this, how do we not consider that implication?
So, Your Honor, throughout the proceeding, the issue has always focused on the statutory text. And on the knowing policy violation prong, the DOA's brief concedes that the only issue is reasonableness, whether the policy was reasonable on its face and as applied to Ms. Jefferson.
But don't we have to interpret the statute in light of the First Amendment rights?
Your Honor, and amici make that argument, but our position is that puts the cart before the horse, because the First Amendment in Article 46, it takes a two-step approach. Does an action, a government activity, substantially burden a religious belief or the exercise of a religious belief? And if so, we go to the second step, which is there a sufficiently compelling government interest to justify that burden? And because no party, neither Ms. Jefferson nor the DUA had ever raised that awarding her benefits would infringe her religious beliefs, there was no reason to establish a record on that second step, which is there a compelling government interest? For example, how many claims did the DUA anticipate receiving of this nature? How many did it in fact receive? How long did they take to process? What was the impact on the fund? What was the status of the unemployment fund and the financial integrity of the program during the pandemic? Another critical issue is, why did the DUA issue a memo, an internal policy memo, setting forth a list of questions for its adjudicators to ask at the initial stage, saying, a claimant will be found ineligible for benefits under the knowing policy violation prong and or the deliberate misconduct prong if his or her failure to receive vaccination was due to a medical condition or a sincerely held religious belief, provided there was an opportunity to see itself recognized that it had an interest in denying benefits to claimants, even those who couldn't comply with the vaccination mandate for religious or medical reasons. It had an interest in denying benefits, and the statutes, in fact, required it to do so, opportunity for the employee to seek an exemption. And that opportunity was provided here. Ms. Jefferson—
I'm confused by what you're arguing. Are you saying because there was an exemption request provision, even though it's denied, that saves the constitutionality of the statute, or what?
No,
or
Your
it
Honor.
just it explains what the agency,
So the point there was, when we get to the second step of First Amendment or Article 46 strict scrutiny to justify a burden on religion, a question that we would have asked the DUA potentially had the DUA or Ms. Jefferson raised below would have been, what was the department's purpose or intent in issuing this memo saying the department could deny benefits under these circumstances? So why was the department doing that? What was the study? What was the analysis? What was the thought process? Because the department contemplated denying religious objectors unemployment benefits provided there was a policy. The issue there is, at the second step of strict scrutiny, why was that policy memo issued?
but the department avoids the issue and the district court avoids it on different grounds. But you know, one of the amicus briefs makes the point we made, which is we got to interpret these statutes in a way that avoids First Amendment problems. And isn't what you're arguing that someone who knowingly, who's not to do something, is still knowingly violating a policy? And that, doesn't that raise First Amendment problems? If, particularly given the U.S. Supreme Court's extremely protective decisions lately in this area?
Your Honor, the United States Supreme Court decisions in this area, Sherbert, Hobby, and Thomas, all got to the second.
You're saying go back, that we have to send this case back? Is that what you're saying? So you have an opportunity to marshal the evidence and cross-examine the department as to why they had phrased the regulation so that it was just an opportunity, not an, in fact, allowance of an exemption?
That would be one position. Is the First Amendment issue itself is waived, and this court recognizes that parties can waive First Amendment issues. In a very similar case, Commonwealth versus Obie, this court found in 2016, defendant who, as a condition of probation, was required to attend a class on Islam, waived the argument that that requirement violated the establishment and free exercise clauses because she never brought it up in the lower court.
Did she win in the lower court?
I believe so, Your Honor, but that issue is still found to be waived.
I'm wondering, because if when you take the victory, you don't marshal all sorts of arguments. I'm wondering if the waiver argument applies in the context here, where she's won.
That's correct, Your Honor. It could be a potential distinction, but there are numerous other cases where a very important constitutional issue was not raised below, raised belatedly on appeal, and this court has found it's waived, and we cite those in the brief.
You keep saying that, but that's still the part that confuses me, that this was brought up as a result of our amicus solicitation, and directly. It doesn't come right out and say establishment cause, but it comes out and says sincerely held religious beliefs. So that amicus solicitation is going to elicit what we got back from the ACLU. But let me just sidestep that for a second. You're making an argument that on the statutory basis in the review that you should win, okay? Do you agree that when it got to Judge Locanto, that he could affirm the agency's decision on any basis that appears in the record?
Yes, Your Honor, he could have.
Okay, so it brings up my concern about the reasonableness of all of this. Looking at the hearing officer's findings of fact, they could be more robust. But one of the things about the reasonableness issue about as applied, there was a lot more evidence here than the hearing officer talked about in the record that was before Judge Locanto, right? So one of the things that you're arguing is, because of the direct contact that she had with the population you served, the offer of wearing PPE or even a full-on hazmat suit just wasn't feasible, wasn't viable, right? But record, that's what she was required to do, because you keep saying, or at least the appearance is that she was going into people's homes directly administering aid. In the record was she worked at a group facility where up until a point, I don't know what the exact period of time was, Fallon required their employees to use exactly what she was proposing. There was also evidence in the record that Fallon set up, I don't know if it was, hospital's too strong of a word, but there was a facility that Fallon set up where people had COVID that were sending in employees like her in with PPE to treat these folks. So in assessing of this offer of exemption, why isn't it that we could just affirm on the basis that you just didn't sustain your burden? Because there's lots of evidence here that what she was proposing was stuff that Fallon already required folks to do, and she was just echoing and offering to continue to do that to save her religious beliefs.
That the review examiner expressly found that Fallon's expectation that its employees receive a vaccination was reasonable. And the DUA has made the point in its brief, well, that's an expectation, not a policy. But the DUA referred to in the same breath before the district court when it acknowledged that.
Is that a factual finding or is that a legal conclusion?
It's a factual finding, Your Honor, and we have cases reviewing findings of reasonableness for substantial evidence. And there are other accommodate that. So you're correct that prior to the Mass Health Bulletin 69 coming out, requiring agencies like Fallon to have its employees vaccinated against COVID-19, Fallon was allowing its employees to work directly with its vulnerable patient population in protective equipment. After that bulletin came out, that changed the way Fallon had to operate. After the bulletin, Fallon also required its employees not only to receive vaccinations, but to continue to wear masks and other protective equipment when dealing with patients. And another point that's important, Your Honor, is there's evidence in the record, testimony from Fallon, that once the bulletin came out, many of Fallon's third parties, the entities that host the Adult Day program where Ms. Jefferson worked and other group homes, required anyone coming onto their premises to be vaccinated against COVID-19.
I get all that, and I understand you're complying with government regulation. But it's the government regulation on UI that's really, what you do with your employees is different from whether they get unemployment insurance. Because unemployment insurance is designed to, be provided for people who are discharged for lots of different reasons, as long as they're not engaging in deliberate misconduct or knowing violations of policy. And I guess interpretation you're asking us to adopt for you to win, I think, is that an employee exercising their sincerely held religious beliefs that they can't do something are knowingly violating a policy and therefore not entitled to unemployment insurance, which is different from getting terminated from a job, right? And also the state is now doing something besides what Fallon's doing. We're preventing these religious observers from collecting unemployment insurance. That's asking for trouble, isn't it?
So two brief points. The interpretation that Fallon advanced here and has advanced throughout the proceeding is exactly the interpretation that the DUA told its adjudicators to apply. And I know the DUA will say, well, that memo is just issued to adjudicators. It's not something that our review examiners have to follow.
But you're sidestepping Justice Kafker's question, which is really fundamentally about the ability, the differential treatment between somebody who receives unemployment benefits and somebody who doesn't. And the difference is because this particular a religious belief. And to me, that squarely presents a First Amendment violation. And you say that issue's waived. I'll go and see if the other cases say that you can waive an argument when you win. A huge problem, I think, for your position, even if the statute literally complies with what Fallon has done, and your interpretation is literally correct. Why would we adopt it when it creates this differential treatment between those who have firmly held religious beliefs and those who don't?
Your Honor, on that point, it gets back to the second step of strict scrutiny
Right,
because
so articulate for me the best case scenario for the state denying somebody unemployment benefits on the basis of their religious beliefs?
well, it could be a number of reasons. It could be the impact these
So
claims.
money?
Financial could be part of it, resources.
In any strict scrutiny analysis, are you aware of any where the money is a compelling enough state interest to preclude a First Amendment violation?
No, Your Honor, but it would be more than the money. It would be the burden on the department in processing these claims, the delay other claimants might face in a claimant for non-religious reasons, delaying their claim and the receipt of benefits because of processing potentially frivolous claims. Another factor would be how many frivolous religious objections did the DUA receive? How many did they find were not well-founded or sincerely held? There could be a number.
Sincerely held religious belief, because you don't challenge that, right?
No, but
okay.
in denying benefits to people who hold
You would
sincerely
be able to
held.
deny benefits to somebody who has a firmly held religious belief because there may be some people who are willing to commit fraud?
Not necessarily fraud, Your Honor, but that could be a factor, just the sheer number of these claims, which is why the DUA concede deny these claims for religious reasons.
Was the district court sort of getting at the First Amendment issue, even if free exercise clause was never mentioned, by saying, this is all unreasonable? Nobody's getting a religious exemption.
I didn't review that opinion that way, Your Honor. There are lots of unemployment cases that have nothing to do with the First Amendment that turn on reasonableness. There's City of Boston, where the appeals
No one's
court addressed
getting a
reasonableness.
religious exemption here, not those other cases. No one's getting a religious exemption here.
I would take the position reasonableness is different from this is a First Amendment or Article 46 issue that can't withstand strict scrutiny. None of that analysis was ever done. None of the parties ever invited that analysis. It was incumbent on Ms. Jefferson or the DUA to raise that issue as the party that would face potential First Amendment issues, and they never did so. And I see that my time is up, so unless there are other questions from Your Honors, I will just rely on my brief for the remaining issues.
Thank you.
Thank you.
Okay, Attorney Yakov.
Good morning, Madam Chief Justice, and may it please the Court. Pretyakov, Assistant Attorney General, on behalf of Acting Director of the Department of Unemployment Assistance. Ms. Jefferson is entitled to unemployment benefits in this case. While her refusal to get a COVID vaccine may well have constituted a good cause to disemployment, that is not an issue that this case presents. Instead, the issue before this Court is whether or not her employer, Fallon, met its burden of proof to establish either a deliberate misconduct in willful disregard of her employer's interests or a knowing violation of a reasonable policy. And the facts and the evidence introduced in this case establish that Fallon failed.
Is the First Amendment issue waived?
Your Honor, I would say that the First Amendment issue here is not dispositive because the Court can affirm the decision of the Department based on...
Yes, I understand your position. Is it waived?
I would not concede to that, Your Honor.
Where was it raised? The amici.
It was not raised below.
Okay, isn't that the definition of waiver?
Your Honor, the best way I can answer that question is there are certain constitutional sort of structural claims that may or may not be waived. But again, Your Honor,
Your opposing counsel suggested that there are cases where the First Amendment, somebody can waive their First Amendment rights.
Your Honor, I will say that In this case, I will be happy to provide the 16 letter to this court if the court requires some sort of briefing on this matter, but
No, so let's just stick with your actual argument. So why under the second prong of that 25A, did Fallon not meet their burden?
So reasonableness of the policy under Steele case requires the inquiry in two respects. One, policy as written, and the other one is policy as applied. If the court looks at the policy as written, and that's page 27 of the record, see that when Fallon was describing the review process for religious or medical exemption requests on two crucial junctures. One, the review of the request itself, and the issuance of the request itself.
But isn't they're complying with the law. I mean, I look at the UI issue separately from the policy, but isn't the how can we say their policy is not reasonable when it's dictated by the state? The state is saying, if you're in this kind of business and you're providing direct care to patients, vaccinate your employees. And they're saying, she's a direct care worker, you're telling us to vaccinate, and she works in homes with the elderly where these people are vulnerable and dying. I can't imagine their policy isn't reasonable. To me, and I can't imagine that she has deliberately done anything wrong, but the issue is whether this is a knowing violation, and that gets really complicated because she does understand the policy. That's why I just think we inevitably get to the First Amendment, because she's knowingly not complying with their policy, and their policy is being dictated by the state.
Your Honor,
And I just don't know how I don't know how you win unless it's the first free exercise clause that provides the win for you. And that may very well do it, but I just don't know how you do it without it.
Certainly, Your Honor. Going back to what previously, the policy itself creates a disparate treatment between religious and medical exemption. So it's
I have to add to that. There's two things. So when you're talking about the reasonableness aperture with this Kafka on this, how you got to get to that First Amendment issue, because with the reasonable issue, you're making an argument that it's unreasonable because there's not the same robust review process that's specifically identified in the policy itself, like they have for the medical. But the evidence before the hearing officer was she did get a robust review process. There was testimony about that the request was made. It was considered by HR. They met with her. They got the letter from her advisor. So the fact that it's not explicitly laid out in the policy doesn't comport with what actually happened. So that's one. The second is you have to also deal with the fact that the hearing officer makes a specific finding that their policy was reasonable. So how do you get out from underneath that in terms of arguing that it was unreasonable if your two bases are going to be you don't have the same review robust policy that's explicitly articulated like they do for the medical, but you got it. And secondly, the review examiner says,
Thank you, Your Honor. To start with your second point, the review examiner said that the expectation that the employee would be vaccinated was reasonable. How that expectation translated into the actual policy and into the implementation, I would argue that's a separate issue. And on the implementation of the policy, Your Honor, we have, again, undisputed evidence that the religious exemption was denied to every single employee of Fallon. Everybody who requested it was denied. At Ms. Jefferson's site were denied it. People who worked on different sites were denied it. And Fallon failed to provide any evidence to the reviewing examiner establishing what those employees' functions were. Were they doing
This as-applied challenge that you're marshaling now and that the district court found persuasive, Was that the basis for the agency decision?
Your Honor, no.
No, and so given that we usually don't make decisions for the agency, even if we can find one out there, wasn't that improper then for the district court, and for you even to suggest that we supply an argument?
Your Honor, in the unique context of Chapter 151A, this court in the past refused to remand the cases to the district court if the substantial findings of fact, the subsidiary findings of fact, were in the record, and they allowed the court to analyze how the principles of law should be applied to those findings. On those cases, I'm referring specifically, I believe, to the case of Jones. The court said that remanding would serve no meaningful purpose where all the findings of fact are made, and the Steele case also speaks about that as well. In this case, again, the court has an uncontested finding that no one from Fallon received an exemption. No evidence in the record
But by the
whatsoever.
way, does that mean no one, meaning corporate-wide, or no one who's a direct care worker got, again, what this record shows? No, when we look at this record, is it going to show that nobody at Fallon got a religious exemption?
Thank you, Your Honor. The finding of fact that I am referring to is paragraph 13 on page 19 of the record appendix. No employees who worked for the employer were granted a religious exemption to the pandemic COVID-19 workforce response policy. We do not know who those employers were.
Yeah, we do. Because again, if you go into the record, you just made a reference that there's no reason that was given, and that's not entirely accurate, because the representatives for Fallon testified that the reason why what she proposed for an accommodation didn't work for people that were involved with direct care, and I think there was actually a specific mention that, say it was somebody that worked for Fallon in HR or some corporate other designation, that person might be able to, but in the specific thing that she did with direct care, that was the determiner. So the fact that it wouldn't be a surprise that you wouldn't find people that were doing direct care that wouldn't get it.
Your Honor is probably referring to the testimony of the HR business partner on page 65 of the record appendix, where she says that everybody who was working on site with direct care of patients, and therefore their exemptions were denied. However, if the court looks a little bit further, and I'm talking about pages 66 and 67 of the record appendix, there that same HR business partner also says there are employees from other sites, different from where Ms. Jefferson was working on. They have applied for the religious exemption. There was a process.
Sites, again, I haven't read the record the way you have, but sites suggests people who go treat the elderly and those who need assisted care. That seems to support Justice George's. We're talking about direct care workers. They're not talking about people at corporate headquarters in the C-suite. They're talking about people who are going to sites, right?
Your Honor, that is an excellent question, which Fallon had every opportunity to present the court with the evidence and which they failed to do. They could have said 17, let's say 17 people requested a religious exemption. All 17 of them were working directly with the patients, and therefore we were not able.
What was the policy? Did the policy apply to anybody who didn't have direct contact with patients?
The vaccine requirement is considered a consideration of employment for staff patients that provide direct contact or having physical contact.
So it's not surprising that the only people applying for the exemption were the people who the policy applied to.
Your Honor, I would say that application of the policy, that the interpretation of the statute regarding the knowing violation, in this case that Fallon is urging upon the court to accept, would still be unreasonable. Imagine that there is a person under Fallon policy applying for a medical exam. Uncontested, undisputed, severe allergic reaction to one of the components of the vaccine. And Fallon says, I cannot accommodate you because of the nature of your job, and we cannot give you any other job within our organization. And that person gets discharged because of that. Under Fallon, according to the logic that the Fallon urges on this court, that person will not be eligible for unemployment benefits. Because
That goes back to Justice Kafka's point, that there's this divide. You can be discharged and separated, but that's an entirely different question about whether or not you should be entitled to benefits.
That is correct, Your Honor. And I think this point, that this result would be completely incongruent with the overall legislative goal of Chapter 151A, in which this court repeatedly said that this has to be interpreted in favor of the employees because the goal is to provide them with financial assistance in some of their most difficult times. And in this case, Your Honor, given the fact that there are some indicia of unreasonableness in the way that the policy is written.
Can I ask, was any guidance given by the UI, I don't know what the agency's called anymore, or the AG's office on this particular problem? Anything from that the AG was telling people who were because the state is telling everyone to vaccinate, everyone in direct care to vaccinate. They know people are going to be laid off. Was guidance issued by the Attorney General's office or the Department of Unemployment Insurance on how to deal with this conflict?
Issued by the Attorney General's office, Your Honor. The memorandum that my brother keeps relying on, one, it's not part of the record. It was not presented before the reviewing examiner, who wasn't bound by it in any way because it applies only to initial adjudicators, and certainly the district court judge and this court are not bound by that memorandum as well. But I will say that that memorandum clearly envisions the due process and the existence of a real and not just illusory religious exemption, because in the last part of the memorandum, it says, where an employer, through interview or some other reasonable process, has found that an employee's professed religious belief either is not sincerely held or doesn't prevent the employee from getting vaccinated, an adjudicator should not attempt to overturn that decision.
Those are easy questions. The hard question really held religious belief. She's essentially the same as the person who will die from the vaccine. I can't do this. It's,
That is
so
correct,
with the
Your
AG, again, this is all Department of Unemployment Assistance internal inter-office memorandum. That's the only thing that's out there on this.
I believe so, Your Honor. I'm not aware of any guidance issued by the Attorney
Counsel,
General.
before your time runs out, one of the things I asked your opposing counsel, I want to ask you the same thing. If the record, because I know that you're more confident in what the findings and what Judge Locanto did and said than I am, but if the record includes something more that we can look to, do you agree that we could affirm what was done here on reasons other than what appears in the decision of the hearing officer or in what Judge Locanto said?
Yes, Your Honor, because the operative statute here that enables these lawsuits, it's Section 42 of 151A, specifically refers to Section 14 of Chapter 30A. And that Administrative Procedure Act statute says that on judicial review, the review is based on the entire record. So as long as it is in the administrative record, which it is both the policy, the reasoning, and all the exhibits that were submitted, the court can confirm on any grounds.
Thank you.
Unless the court has further questions, I will rest on my brief.